Good morning, good afternoon, and good evening. This is Pamela, and you are watching Pam Entertainment TV, where we review movies, television series, and incidents in pop culture to see how those incidents may or may not affect our daily lives. Listen, please like, comment, and subscribe. Please share this video if you care. I am on a quest for 3,000 subscribers. So if you have not joined the family, please subscribe. And once you subscribe, you will be open to a plethora of movies and television series that I have reviewed. Also, you will be open to all the different pop culture chats that I have completed. Okay? All right, people. Really, really quick. If you have not checked out the live stream that was done on Cat's channel, and I also simultaneously streamed that on my channel as well, check it out. Start off with Cat's live stream because that talks about the information that I'm going to talk about right now. Start there and then go over to my live stream or continue on hers, and you can hear the whole thing. I think her live stream was like ooh, it was almost 5 hours. However, I do know that she's going to chop that up. But again, check all our streams out. Danny, that does this and that on here on YouTube. She was also on the live stream. The chat was amazing. I do love the interaction like that with the chat. So please, please, please make sure you join and follow all of the creators that I just mentioned. Listen, so what I wanted to go over here real quickly on my channel is to talk about the happenings of today. Now, we have been told since December, since the conviction, that Jonathan Majors was going to be sentenced on today. Well, as we waited for to hear what the sentence was, I think I remember a couple of videos back that the press had put in a motion to have the uh, information that was not allowed to be brought out in the trial because it would have been prejudicial, and it would have it would have been prejudicial to a jury pool and things like that. We do have a press lawyer that was wanting to have this information released. They feel like that the information no longer will taint the jury, and so they want to know the information that was sealed from the judge. So they have pushed forth a motion in regards to that. Uh, Pundits said that different pundits were talking about that they possibly would rule on that today. However, what no one talked about was that Priya Chaudhry was going to beat them to the punch, and she was setting out a new motion to have the conviction vacated. So let's go over this article now. There's two articles. There's one by Business Insider, and there's also another article by TMZ. And we will go through them both just for the language. Each article has a different language that they're talking about, just in regards to how they just put their headlines. Now, this one on Business Insider was written by Lori Italiano, and as we go through it, it says former Marvel actor Jonathan Majors has asked to void his December domestic violence conviction, delaying his sentence until April 8th. So, excuse me. Majors was to have been sentenced on Tuesday on a reckless misdemeanor assault charge and a harassment count for a scuffle with his ex-girlfriend, Grace Jabari, last March. So let's get some clarification. The misdemeanor assault charge carries up to 1 year in jail, while the harassment count is a violation and you pay a fine. Um, Instead, he appeared virtually on a large screen monitor at a brief Manhattan criminal court hearing. I feel very uncomfortable about these virtual hearings because there's always some mess that happens within these virtual hearings, and in particular with this case. Uh, There he learned that his lawyer motion to set aside his verdict had been received by the judge. The so-called 330-30 motion was not immediately provided to the public. Follow Kat's screen. She at the beginning of her live stream today, she outlines what this uh, 330-30 ruling ruling is, and all the different aspects that you have to meet in order for this to meet the criteria. So apparently, uh, Priya Chaudhry put in a motion that she believed met the criteria. There's three different things. One had to do with judge's ruling. I think the second one had to do with there was problems or things with the jury or someone surrounding the jury. And the third one had to do with new evidence that had not been entered and was not available to have been entered. And this evidence has the ability to sway, that could sway a jury in their deliberation process. So go back and check that out. I've just overviewed it. So let me just continue. The actor also learned of some new dates. Manhattan prosecutors have until March 5th to respond, and his lawyers have until March 12th to respond to that response. Majors wore a dark tan sweater and answered, "Yes, sir." Da, 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 da. The actor leaned toward the camera as Gaffey paused to consult the calendar and set the most important dates in the case of all for a decision on the motion and sentencings if the motion failed. "I'll try for a decision," the judge began, his voice trailing as he appeared to scan his calendar for a good wait. "Give or take April 1st," the judge said finally, and Majors leaned back away from the camera again. "And we all agreed at the sidebar that a good day for sentencing is April 8th. So Mr. Majors, we're going to be adjourning your case for sentencing," the judge said, turning to face the Majors on the screen. "There's still a motion that needs to be resolved. I remind you that the order of protection is still in effect and you must abide by all the mandates already in effect," the judge said. He says, "Yes, sir." And again, it goes, his 330-30 motions are kind of legal effort only filed before sentencing, and they are rarely successful. But the motions named after a section of the state criminal procedure law do allow a judge to set aside a verdict if one of three things happen. First, a verdict can be set aside if the defense uncovers anything already in the case record that would reverse, or modify the verdict on appeal. This first category is the longest of the long shots, as it would require the trial judge, Gaffey, to admit to a reversible error on his watch. So, and you know, judges don't want to admit that when they're wrong or incorrect, they'd rather you take that up to a higher level. They don't want to admit that. A verdict can be also set aside under the 330-30 if the defense uncovers evidence of improper conduct by a juror or anyone connected to a juror. So that may be something. Again, we don't know what's going on, so we don't know exactly what they have. And lastly, the statutes lets a judge set aside the verdict if the defense provides new evidence discovered since the trial that could have resulted in the defendant winning the case. So it's unclear about which one of these three or a combination of three that we will see that they have. And so, like I said, this is something that the defense has, and the defense has the burden of proof to prove one or all, or a couple of these different tenets in the 330-30 rule. What are you all thinking about this? Do you all think that there is something? I'm quite sure that the defense has a lot of some things. I don't know exactly what they do. I'm assuming that they're going to be going through the judge's ruling and in those different things in the case, and the things that he said. I'm sure that they're going to go through those types of things. I don't know if they know of any jury tampering or anything like that, or if there was some improper things going on with the jury. I don't know if they have that, or unless they're trying to show that a juror was on their social media talking about this case. This juror was talking to somebody else on this case, and started going over the ins and outs of the thing, and seeking an opinion from an outside source outside the jury room. I don't know if they have that. I don't know if they have new evidence. If there's new evidence that they can provide, uh, that was not presented in court, that's going to be interesting. But tell me what you all think. This right here is just the TMZ, basically the same things. Um, it's basically saying the same things. Uh, And so here they just give a little synopsis of what they believe. It says here, long story short, we're told that JM's team believe prosecutors argued that the assault was intentional throughout the trial, but then they ended up giving the jury instructions about convicting him for a reckless assault, offering up a separate option for a potential conviction on something they weren't really arguing throughout the course of the trial. That's why his lawyer believed presenting the reckless assault to the jury wasn't justified and should have never been on the table at all. Bottom line, uh, Major's team does not feel like he got a fair shake, and because of that, they're asking the judge here to throw out the verdict. Okay, so I don't know, lawyers that are out here who understand all of this legalese, because to me, just me trying to make any sense of it. It sounds like they're saying that the prosecution spent the time trying saying that he was a menace, and he has been a menace for a very long time in that relationship. I think this is why we got the Coretta Scott tapes. This is why we got the text messages. They were showing a pattern of assault and harassment by Jonathan Majors, and they made the thing. And then at the end, particularly when the driver testified that it was the girl doing it, the girl was doing it all. The girl was fighting and hitting and things like that. Once that happened, they said, no, 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 don't believe that. Uh, Everything didn't happen in that car like we talked about it. Because at first, when they came on, they were saying that Mr. Bari was hurt and assaulted inside of the car uh, when the car stopped. Then they said no, she was hurt and she was assaulted outside of the car. And then they come back and say, oh, no, 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 no. She was hurt and she was assaulted uh, uh, in the last car when they jumped out of the car in traffic. Because remember, there's car one, there's car two, and there's car three. Those are the three separate incidents. And they're saying that she was injured in car three. And so they're saying for us to believe that at the end, they argued throughout the trial that everything was intentional, that they showed a pattern of his intentionality. And then at the end, after the driver testified, then all of a sudden, well, he really didn't really mean to do it. He did it, recklessly. So you all need to charge him on the reckless. You have to make up your mind. If you believe that it was intentional, then you should have believed that it was intentional all the way through. And that's my issue and my problem with the prosecution being able to throw all of these charges out and then let something, until something sticks. I think that if you believe and you argue that this was intentional, those should have been the charges on the line. There shouldn't have been reckless and the fine or anything like that. It should have just been the intentional this and the intentional that, and left it alone. But that's just me. What are y'all thinking about this? Again, please like, comment, and subscribe. I really do appreciate it. Please also note that once I get to 1,500 subscribers, I will be doing a $50 giveaway. So please stay tuned for that. So please tell a friend, tell a kin, tell your coworker, tell that heifer that you can't stand that I'm over here making these videos. All right. we will see you all again for the sentencing in April. There may be some more information to go over because I'm now interested in a timeline. Uh, Kind of going back and just to do a timeline. I'm gonna see if we can get Danny and get Kat on here and go over this timeline. Uh, because there's a lot of stuff now that we want to think about between now and April. All right, people, we do this every week. And as always, bye bye.